Tonight, a growing online debate is putting a spotlight on pregnant women's bodily autonomy and Florida law.
Monday here on First Coast News, we shared the story of Sharice Doyley with you. She's a Jacksonville mom who, while in labor in 2024, appeared before a judge from her hospital bed. The court was asked to decide if she should be ordered to undergo a cesarean section against her will.
Now, a similar case unfolded in Tallahassee in March 2023. Brianna Bennett was ordered by a judge to deliver by C-section despite her adamant request for vaginal birth. Cases like these are fueling some very strong reactions. And as On Your Side's Keitha Nelson reports, serious questions are being raised about Florida law, maternal rights, and the legal status of the unborn.
It felt like rape to me. It's because I'm saying, no, I don't want you to do this to my body. And you force what you want on me, my body, my baby. So, I did call in for the patient advocates.
Brianna Bennett pleading her case while in labor, pausing amid contractions.
So I understand it's an emotional issue, but I hope that people understand that, to me at least, it was a life or death decision, and I chose life.
State Attorney Jack Campbell received a rare call in March of 2023 from Tallahassee Memorial.
I had a doctor telling me that she could have died that night and her child could have died, and she would have orphaned the other children who we could watch playing in the room. That would have been a horrible tragedy, and I could have never forgiven myself if I had let that happen.
Bennett had been in labor more than 24 hours after 3 prior C-sections. She wanted this, her 4th child, delivered vaginally.
There are times that cesareans have to happen. There are times that it does actually save babies and women lives. But for me, I knew that none of the 3 prior cesareans were medically necessary.
First Coast News reached out to the American College of Obstetricians and Gynecologists. While not commenting specifically on Bennett's case, ACOG tells us vaginal birth after cesarean carries risks, including infection, blood loss, and in rare cases, uterine rupture. But patients, they note, should be allowed to accept higher risks if fully informed.
So I did all of my research, and I realized that I had a chance. I had a fighting chance to have my baby the way I wanted to birth. I wanted the opportunity to have vaginal delivery, and I was willing to do whatever it took.
A C-section, she argued, would make it harder to care for her children and her sick mother.
The law is meant to be logical, and so, you know, the option for me as a lawyer and as a person was the child lives or the child dies. I'm going to choose the child lives every time. Same thing with the mother.
Under Florida law, the life of an unborn child can outweigh a woman's right to bodily autonomy, allowing courts to intervene.
Pregnancy is the only condition in Florida where a competent adult can be forced to undergo a major surgery against their will.
Robin Powell, a law professor at Stetson University College of Law, points to a decades-old case.
In Florida, we had the Pemberton case, and that was really the cornerstone. In the Pemberton case, a federal judge had held that the state's interest in an unborn child outweighed a pregnant woman's constitutional rights to bodily autonomy and religious freedom, and that ruling has never been overturned.
Pemberton versus Tallahassee Memorial Regional Medical Center, filed in 1999. More than 2 decades later at the same hospital.
Yes, I am 41 weeks pregnant currently. The reason for a C-section is not an emergency.
Cell phone video shows Bennett testifying from her hospital bed, surrounded by medical staff, during a live court hearing over Zoom.
Hospitals and prosecutors who once maybe were more hesitant to bring these cases seem to be now more willing to pick up the phone and call the judge. It's this idea that the fetus has rights, and sort of once you accept that a fetus has rights equal to or greater than the person carrying the fetus, then forced surgery stops being sort of unthinkable, I think, and starts being sort of more predictable.
I felt alone, number one. I had no legal representation. I wasn't given the opportunity to have legal representation. I felt ganged up on. I felt like a criminal.
Campbell says his office contacted a public defender and tried to retain counsel, but unfortunately, that did not work out. On March 30th of 2023, Bennett would give birth to little Aubrey via cesarean as ordered by a judge.
You have lawmakers, oftentimes men, who are putting forth legislation because they want to control what a woman can do with their bodies, particularly marginalized women.
State Representative Angie Nixon, now running for U.S. Senate, opposes fetal personhood laws. A related bill, civil liability for the wrongful death of an unborn child, failed this session.
Thank goodness that failed. It's a slap in the face for women.
Supporters say such measures close legal gaps, while critics warn of broader impacts on health care and reproductive rights.
We need to look at some comprehensive reform around that and making sure that we are passing legislation that prioritizes Black maternal health and the health of a child.
Go ahead, Ms. Smith. What did you want to say?
Okay, so it's painful to know that I went through that and I still don't have all of the answers. I still don't know how to fix it. I do know that there's a problem, and I do know that that problem has to change. We have to find a solution to that.
That was Keitha Nelson reporting tonight. Now, Bennett noted similarities between her case and Doyle's. Both are plus-size Black women who gave birth without a male present. Campbell says those factors did not influence his decision to proceed with Bennett's hearing. Tallahassee Memorial has not responded to our request for comment. Both Bennett and Doyle have started an online petition pushing for accountability. To learn more, visit this story on the First Coast News app.